Hello, everyone. I'm Mark Schondorf, partner in the law firm Hecht Schondorf, streaming live on Facebook, and we've got a Zoom meeting here all at the same time. First time we're doing this. It's very exciting. We're trying to figure this out, and hopefully it all works out. Hopefully you guys can see me. And what we're doing is we're doing a general Q&A on divorce issues, all kinds of divorce issues. I'm an open book. We're going to talk about whatever it is that people come up with in terms of questions they might have. It could be related to child custody, child support, business valuations, how assets are divided, agreements, how long the process takes, going to court, not going to court, everything in between, everything that has to do with divorce. So we have here is we got a couple of participants here on the Zoom session, and we're also going out live on Facebook. So what I'm going to ask is if you are on the Zoom session and you have any questions, go ahead and open up your chat window. Hopefully, in the age of COVID-19, we've all been getting used to doing our Zoom meetings, and so now we know how to do Zoom chats. So why don't if you have a question, go ahead and post it up in the Zoom chat, or just get on Facebook, write a comment if you're watching this on Facebook. Let's see, hold on. Is a big that depends on the facts of the situation. So what's going on here with support? If you're paying them spousal support, the reason you're paying them spousal support is because they are entitled to have some little financial help to maintain the lifestyle that they were living during the marriage, and that number is whatever that number is. And so if they start all of a sudden getting collecting a retirement support, Social Security, whatever the case may be, if they retire, they're going to be presumably drawing income from somewhere, and that could be from retirement assets. It could be from Social Security. And so the question is, how much of that, how much support are they getting? And is that enough for it to be a substantial change in circumstances such that they do not need your support anymore? So for example, let's say somebody's paying $2,000 a month in spousal support, and now the person retires, and that person is now drawing $2,000 a month from Social Security or retirement assets. Well, now you have a good leg to stand on, saying, well, they have all the income that they need, so I should not have to pay them anymore. However, imagine if you're paying $5,000 or $6,000 a month in spousal support, and now they're drawing $2,000 a month. You might be able to get a modification because now they are supporting themselves for that difference, but you might not get the entire amount reduced or abated or ended. So it really does depend on the facts and circumstances. Spousal support, that gets changed based on a substantial change. So if somebody's making a lot more money or a lot less money, that is usually a cause or a reason to go into court and try to get that changed. So I hope that answers that question. Let's see. Lawyer. And the answer is yes, you can use one lawyer, but no, because one lawyer cannot represent two people. See, the two of you have interests that are competing. You both want what's best for yourselves and not for the other person necessarily. And the lawyer's job is to make sure that our clients are protected. So I can't represent the interests of two people whose interests are against each other. That's what we call a conflict of interest. So what would happen is I would have one of the people involved would be my client, and the other person involved would not have a lawyer. So that's a little bit of a dangerous situation for that other person, because they are basically making a deal and participating in a court proceeding that can affect their legal rights without an attorney. And so everything might be amicable if everybody thinks that the deal that they're making is a good deal and everybody thinks that they're happy and they believe they understand everything. It's certainly not uncommon for only one lawyer to be involved. But the difference is that one person doesn't look out for everybody. That one person looks out for their client. So again, when clients come to me and they ask me this, I say I can do it. The difference is if there's something in the deal that's bad for my client, it's my job to let them know that there's something bad in the deal. If there is something bad for the other person, it's not my job to let them know. And, it's not my job to educate or inform them. So that other person would necessarily be proceeding without a lawyer. If you get divorced without a lawyer, judges don't really have that much sympathy for you because they feel that you have had the opportunity to obtain a lawyer. And certainly in a divorce case, you're going to end up saying that to the judge, or it's in the divorce papers themselves. And so coming back later saying, hey, I didn't get a lawyer, I didn't know what I was signing, probably isn't going to save you. Now, it's not uncommon for the other person to just hire a lawyer for an hour of their time and say, hey, this is my deal. What does it mean? Where are the corners? What should I be looking out for? Or am I making a bad deal? And that lawyer might just, advise them, but wouldn't represent them. Representing means that, that lawyer does the talking for their client. They would send the emails and the letters and appear in court and things like that. But you don't have to have a lawyer actually represent you in court. You can just consult with them. And if, that certainly reduces the cost, reduces the complications. But certainly if everyone's okay with just having one lawyer, certainly the deal can get done with only the involvement of one attorney. So I hope that answers the question. I know that before we got our Facebook Live going, we had another question with regards to what happens when one spouse retires. The question is, if your spouse retires and collects Social Security, you will not have to pay them support. And the answer to that is maybe. It's going to be a common answer from a lawyer. It depends. And the answer, it really depends on how much support are they receiving and how much Social Security are they going to be getting, because the whole purpose of spousal support is to support that person in some similar lifestyle to help them live their life. Now, if the support that you're paying is somewhat roughly equal to the support that somebody is going to be drawing on Social Security, well, then there's, if a good basis to tell a judge, hey, judge, I was paying $2,000 a month in spousal support. Now they're getting $2,000 a month from retirement assets or Social Security, whatever that number is. So why should that person be receiving that twice? A very good, that's a very good justification to end the spousal support. However, if somebody's paying $3,000 a month in spousal support and Social Security is only $1,000 a month, you might be able to get your obligation reduced by that $1,000 because now they're receiving that support from some other source. However, you also can get your spouse support reduced or abated or terminated if somebody's making a lot more money or a lot less money. If you're paying spousal support and you lose your job for whatever reason, but for a valid and good faith reason, you might say, hey, I don't have my job. I can't pay this amount of money. So I shouldn't have to pay this amount in support. And a judge might believe that if everything's in good faith. If the other person, for example, is receiving support, and now they start making a lot of money doing something, or they get married and now they're sharing a home with someone else, that would be a reason to stop paying them support as well. Big thing about spouse support and child support, you can't just unilaterally on your own decide, I'm going to stop paying this. You have to get the court's approval. And there are situations where even if you have an agreement, you kind of talk to each other and you say it's okay, it's still not okay. It's, that the person who said it's okay can turn around months later and say, I didn't really mean it and I want you to pay the whole thing. And until a judge signs a document saying it's over, it's not really over. So hopefully that answers that question. Frequently asked questions. Probably one of the most frequently asked questions I get is, how is child support calculated? What does it mean with regards to child support? And we used to have child support used to be sort of very unilateral. It was really a very simple calculation. We would essentially look at one party's paycheck and we would say, you're paying support because you have the kids less than 50% of the time. And so you're going to pay support and we're going to chop your paycheck up. And depending on the number of kids, that's how much you're going to be paying in support. And that has changed very, very significantly. The change is now that we look at what each parent earns, and we also look at how much time each parent has with the children. We look at the number of overnights. So in the old model, the old style of thinking, we would look at this and we would basically say, well, if you had the kids 49% of the time, then you have them less. So you're paying support to the person who has them 50% of the time. But now we realize that more and more parents are having split, parenting time, split custody type situations. Dads are getting a lot more time than they used to 10, 15, 20 years ago. It used to be very standard, okay, every other weekend, that's about it. And now we're getting, dads who are a lot more involved. And what that means, the reality is if you have your kids 49% of the time, you still have to pay 100% of your rent. And you still have to have extra bedrooms for them. You still have to pay more for food when you have them, utilities, gas, and all that fun stuff. So it's not really fair to say, well, you haven't half the time, you're still paying all this money, but you have to pay all of the support. So now we look at the parent's income, and we add it up, and we basically say, this, for this household income, we have this number of kids, this is the amount of support that they need in total, and then it gets divided up based on the amount of parenting that time that they have. The number of overnights is really what counts. And if we have a situation where both parties have more than 40% of the overnights. So it's a situation where each party has 40, 50, 60%, depending, but really you have a split parenting time situation where it's really week on, week off, or close to week on, week off. Then that really does change the numbers pretty dramatically, and it sort of slides. The more time you have going from one side to the other, the amount slides. And will change. So that's really a much more complicated process. All right, we got another question. What is the typical length of the divorce process? Is there any way to expedite if special circumstances such as a life-threatening illness? So that's a really, really good question, because that issue doesn't really come up a lot. The length of a divorce really depends on how willing each party is to participate and move that divorce along. So you can, I think my personal record for getting someone divorced is probably 4 to 5 weeks from when they came into my office to when they were actually divorced. And that is a situation where they had an agreement. They knew exactly what they wanted to do. We sat down, we drafted everything, we signed everything. And then only because the court had delays in scheduling and filing things, that's why it took that long. That would probably be now especially in the age of COVID-19. We moved on to the online platform. There's a lot of Zoom court going on, and there's a lot of electronic filing, and I could probably shorten that to probably 2 weeks at this point. That's probably the very, very shortest. If everybody is cooking with gas and is super committed to getting the divorce done as quickly as possible, that can happen. On the long end, you can have cases that go on for years and years and years. And so I think the record I've ever seen, I was at a firm that had a divorce case that was going on for 10 years and they were still not divorced, which is insane. So in that situation, the case had gone up to the Court of Appeals a couple times and back down to the trial level. And that's sort of an outlying example. I did a trial, usually it could be 2, 3, 4 years from the time it's filed to the time you actually get to a trial. There are rules that state that if we have custody issues, those have to be determined within 18 months. So that's usually at the forefront of the attorneys and the judges' mentalities. And that's their goal, is to get those things determined pretty quickly. But 18 months doesn't sound too quick. I would say that a typical length of a divorce, if we're really trying to get into the nitty-gritty, can take certainly over a year, possibly 2 years. It's rare that I have a case that goes on for more than 2 years, but certainly if everyone's dragging their feet, it could totally happen. So now the second part of the question is there any way to expedite if special circumstances exist, such as life-threatening illness? And the answer to that is yes. And what we do, that is called a bifurcated divorce. So what's a bifurcated divorce? You are splitting the divorce case up into 2 parts. And the first part is actually getting divorced. And that is changing your legal status from a married person to a not married person. And that has some very, very serious legal effect, because when it comes to estate planning, if you're not married, then your spouse or wouldn't have, or your former spouse doesn't have the same rights to inherit. There's also issues when it comes to beneficiary designations, and there's also issues that come up to, for example, end of life decisions. Who can see you in the hospital? If you're married, your husband can see you in the hospital. If you're not married, they probably can't. So that can exist. So you're dividing this case up to deal with just changing you from a divorced person to an undivorced person. And you're basically saying, hey, judge, we're going to deal with all the other financial issues later. We need to get divorced now. There's a reason we need to get divorced now. And so we'll just deal with how to split everything up later. And it can get pretty hairy, but it could be a good reason to divide that up. So there was, I know that I researched this issue. I argued it once, where a woman wanted to bifurcate the divorce because there was an immigration issue, and she was afraid that if she remained divorced, and the husband stopped sponsoring her, that she would get deported. The judge didn't believe that because of expert testimony from an immigration attorney. But there was a case that basically a woman wanted to get divorced because she got pregnant with another man and she wanted to marry that other man. And so the judge said, well, that's fine. We're going to do that. There was even a situation where where there was a husband and wife got bifurcated the divorce, and then he married somebody else and then died. And so literally you had the old wife and the new wife fighting over the marital estate of the old wife. So that was a pretty hectic situation. But if there's a life-threatening illness, circumstance, certainly if they're in the middle of the divorce process and somebody gets a diagnosis of something that's very grave or terminal, bifurcating the divorce certainly is a possibility. And that way the person can do what they want with their estate. It would be undetermined. You don't know exactly what you got, right? So the idea is that a person would want to pass on their assets to their children or wherever they want to put in their will, but you still have to determine what the marital assets are, right? Let's say the husband is the one who has this terminal illness. We still have to he can only give what is owed and what he owns. And so if he instead takes the let's say there's a house involved, right? How much of that house is he going to get? Is he going to get 40%, 50%, 60%? Are there debts? The debts come out of that house. He doesn't know what he's got, but he would be able to get divorced and then on his, before he dies, say, well, whatever I'm getting out of my divorce, that's going to these people and designate it. So certainly that would be a very, very good circumstance or a reason to bifurcate a divorce. I see we have a couple more people on the Zoom call. So just so you know, if you have any questions about this, go ahead and post them on the Facebook live feed or in the Zoom group chat. Just pop them up there and we'll answer them. Jill? Can be. So a business, here's the fun part. So when we talk about business and divorce, probably the biggest issue and the biggest concern I get from people is, if I own a business, is it going to be divided up in a marriage? And we have to understand whether or not there's an asset is marital or non-marital. And so a non-marital asset is basically anything that you own prior to the marriage, anything you inherit, or anything you receive by gift. And then anything you sort of exchange those three things for. So if you got a nice, you had a nice watch when you got married, that's your nice watch. And if you sell that nice watch and you buy something else, assuming you can prove it, that's something else, that other nice watch or whatever, is going to be your non-marital property. And similarly, a business, your business interest, if you have a business and you get married, that business interest is your non-marital business interest. If you start a business during the marriage, then that business is marital. And it doesn't really matter, where the money comes from. You can say, hey, I had, $100,000 sitting in my non-marital stock account, brokerage account, and we got married and I decided to start a pizza shop. So I took my non-marital money and I went ahead and I started my pizza shop. Well, you might think, hey, didn't you just say, my non-marital watch for my other non-marital watch? Well, I'm taking my non-marital $100,000 and I'm trading it up for my non-marital pizza business. But that's not the case. You are starting a business, and any businesses starting during the marriage are marital. So that is where that comes into play. Now, we can get a little more esoteric, where let's say you owned a couple of pizza shops before you got married. Isn't that nice? And when you have 3 pizza shop locations and you get married, well, those 3 pizza shop locations are your non-marital business. But what happens if you open a 4th pizza shop during the marriage? What's going to happen? What happens is, even though that is the original 3 are a non-marital business, and they might be in a non-marital corporation business entity that you had prior to getting married, and you used non-marital profits for those to open that 4th pizza shop, there is case law here in Illinois, certainly, that says that 4th pizza shop, it's its own little business unit. It is like its own independent business, and you started your own independent little business during the marriage. So that 4th location is marital. And that is something that really trips a lot of people up, trips a lot of lawyers up. And it's something for everyone to understand. And then there's ways around that, depending on how it is financed. And it doesn't really make a lot of sense, because if you just took the money and put it in, into your non-marital account from that non-marital business, it would remain non-marital. But if you collateralize the business, not a non-marital property, then it would remain non-marital, that new location. But if you don't, it is marital. So that's certainly a complicated question. If anybody who's getting divorced or contemplating divorce that owns a business, that is definitely something to look out for. So that's how there are so many other business-related issues when it comes to divorce. I think one other thing I'll go into, because we were talking about child support before, And child support from a business income is certainly always a hot topic. So what happens, how do you determine someone's income when you, for child support purposes, when you've got a business at play? And a lot of times what happens is people will it's hard to play games with your income if you just have a job, right? You get a job, you get a paycheck. At the end of the year, you get a W-2, and it tells you exactly how much money you made. And if that's the case, and you know exactly how much money you made, then it's right there in black and white. That's your report to the IRS, and it's pretty hard to move numbers around because you're not in control of those numbers. Your employer is, and your employer certainly isn't going to bend over backwards for your divorce case. They don't want to get in trouble with the IRS. So those numbers are pretty trustworthy. What happens when you are reporting the numbers because you own the business? There's a lot of places to hide money in a business, and so of course it takes a lot of sorry about that. It takes a lot of know-how to understand and read a tax return and do a little bit of digging to figure it out. So what we would do there is, business income is, for child support purposes, is the regular income that you draw from the business. But we want to make sure we're not taking out accelerated depreciation of business assets, which basically means you buy an asset, you get to deduct it off your taxes and not pay taxes. Oh, what's going on here? Sorry about that. Take it off your taxes so that you don't have to. So when you eventually replace it, you got a little bit of a benefit, but that can be used to hide income. Sometimes we hide some personal expenses in our business: cell phone bills, lunches out, cars, related expenses, car insurance, health insurance, things like that, that you can use to sort of muddy the numbers up. So I've many times, in many cases, I've had other attorneys on the other side that give me a tax return saying, "Look, my client makes so little money. He or she should not be paying so much in support." But the reality is that you do a little digging and you say, "Sorry, but you're depreciating some business asset over 5 years instead of 20. We're hiding money in there." Or let's find out how much money you spend on business lunches and add that back in. Courts don't really like that. So that's only some of the business issues that come up in a divorce case. We have another question here. What is the significance to the number of years you've been married when filing for divorce? So that's a good question. I was really surprised when I got into this business when I would see a marriage that was 6, 7, 8 years old, and it was referred to as a young marriage. It was a relatively new marriage, and I thought 8 years sounds like a long time. But that is not the case. So probably the biggest one that jumps out right off the bat would be spousal support, right? We're talking about how long, if you have to pay spousal support, how long are you going to have to pay that support to the other party? And that is a direct function of the number of years you're married. And that's if we're using the statutory guidelines. There's not a reason to sort of deviate from the guidelines. And there is basically the longer you're married, the higher it goes. So anytime in the first 5 years, you're basically paying support, whatever amount you're paying, you're going to be paying it for 20% of the length of the marriage. So a 5-year marriage, 20% would be 1 year. So you're paying spousal support for 1 year. But the longer your marriage, every year it goes up, I believe, about 4% of the length of the marriage, until you get to about 20 years where you're at 100% of the length of the marriage. So if you're married for 20 years, now somebody is going to be paying either 20 years, or once you get past 20 years, you have a possibility of a lifetime of spousal support. So, versus 1 year when you're married for 5, now it's 20 for 20. So that number is pretty much catching up. And that is probably the most significant issue that comes up. The other issue when it comes to spousal support can be, there's a lot of factors in determining whether or not someone's going to get spousal support, whether or not somebody's going to, and what amount that's going to be. And the factors that we look at is, what are the economic prospects of one party versus the other, and whether or not one party has given up economic prospects for the sake of the marriage. So if you have a situation where one person spent the entire marriage building up their career, now they're at the top of the ladder, they're making a lot of money, and the other person did not spend their the 20 years working their way up the ladder and honing their skills and becoming more economically valuable. They spent their time at home raising the kids and making sure they got all their homework done and packing lunches and off to school and through college. now we're at a place where the marriage is 20, 25 years old and people are getting divorced, and that other lesser economically advantaged spouse isn't going to be able to find a job in the workforce. That's a factor we take into account. We say, hey, they're never going to come back and make it to where the top of the ladder executive spouse is going to be, that's making deep six figures, or whatever the case may be. So that's where that significance comes in. Probably the two biggest spots. There are other spots where it comes in as well, in terms of assets, in terms of practical matters. How far back are you going to be able to get records to prove that something is marital or non-marital? If it's only 2 or 3 years ago, that's not a big deal. But if you're trying to get bank records from 17 years ago, that could be a little bit of a challenge. So hope that answers that question. I know we got a couple people, more people on the Zoom chat now. So again, if you have any questions, just pop them in the chat. Here's another one. What if one of the spouses spent their time sitting on the couch drinking instead of advancing their career, not taking care of kids or home or anything? So now you got an interesting scenario, and there is sort of a way that judges look at this, and they basically say, well, that's who you married, right? So that's on the one hand, you don't want to have somebody that is voluntarily reducing their income, but on the other hand, there is something that we look at sort of the status quo of a marriage. So let's look at the first part: reducing your income. So what you're not allowed to do is voluntarily reduce your income to make it seem like you don't make the money you're supposed to be making. So if you're in the middle of a divorce case, sometimes we call, as a joke, because there are jokes in the divorce industry, surprise, surprise, we call that SIDS, sudden income deficiency syndrome, where somebody's doing really well and all of a sudden the divorce is upon them, and guess what? Their business has gone bad, or they aren't earning what they're supposed to be earning. They're not making the commissions they're supposed to be making. They're not working the overtime hours that they're normally working. And so, now they're saying, well, I only make this much money now, I shouldn't have to pay this much in support. Judges don't like that. And there are ways to prove it. We can look at historically what a person's been earning. Historically, look at their job. If somebody's been earning average of 10-hour overtime hours for the last 3 years, and now all of a sudden they don't have any overtime hours and they're cutting hours, that's not good. But on the other hand, if somebody really, if the tenor of the marriage, if somebody's married for 10 years, and for the last 8 years, somebody has been not advancing their career, and they've not been working very hard, and they've been just sort of getting by and being lazy, at some point the judge says, well, that's who you married. You married somebody who is just getting by and is lazy. And I'm going to flip this. There's another context. I see this a lot. It's not too uncommon. Is, husband and wife get married, have kids. Wife stays home with the kids, and this is very prototypical. This is not obviously everyone's situation, but wife says, I'm going to stay home, I'll take care of the kids, and once the kids are in school, I will go back to work and get a job, and we'll be a productive power couple. And then what happens is that after the kids are finally out of the house, they're in kindergarten, they're in first grade, they're in third grade, whatever it is, and the wife does not go back to work. And so now the husbands are really angry because they say, hey, we had a deal. She was supposed to go back to work after the kids went to school, and now the kids are in high school, and she hasn't worked in 8 years. And what am I supposed to do about that? And the judge will say, a lot of times, well, that's who you married. Now, after a divorce, a person does have a responsibility to take care of themselves. They do have a responsibility to try to support themselves. And if you have a situation where, hey, they can go out and get a job and make 40 grand a year, then that's not, I don't want to cast aspersions, but that's sort of a basic $20 an hour job doing whatever it is that they need to do to get by. That's one thing. Now, if the person's never going to, like I said, never going to get to that level, hey, someone's entering the workforce at 55 years old with no skills, and they haven't worked in 25 years, what kind of job are they really going to get? That's a totally different story. So hopefully that answers that question. Do we have any? We got a lot of people liking this video, so that's awesome. Very excited about that. We got a couple of comments. Let's see what it is. I get some regards from Belgium, so that's good. Hopefully divorce works in Belgium too. I'm sure they have that. Do you have any other questions? I know it said we got another couple of people. Someone joined in just by phone. I'm going to answer probably one of the other more typical questions. We're going to pivot. We're going to not talk about the money issue. We're going to talk about how do we decide custody? How do we decide parenting time? How does that work? That's probably, the biggest concern that most people have if they're getting divorced and they have children. They want to know what what is this going to look like, and how is this going to get determined. I'll talk about the process. So everything is really geared towards looking out for the best interests of the children. So what does that mean? The best interest is a very, very subjective standard. There are a lot of factors that a court will look at to determine what's in the best interest of the children. But typically, the court system is you can make any deal you want with regards to money. Pretty much, you can make a deal on spouse support. You want to divide your assets, totally lopsided. That's not a big deal. You want to waive spouse support, go right ahead. But courts really, really do care about the kids and want to make sure that the kids are being taken care of. So the first thing the court's going to do is they're going to send you to mediation, right? You tell the court, hey, I want to make these decisions. And the other person says, I want to make the decisions. So the judge is going to say, well, you know what? Go to mediation, see if you can figure it out. And you're going to work with the mediator. And some counties offer it for free. Some counties offer it for low bono, lower amounts. And they'll try to help you make a deal. What are you trying to decide? You're trying to decide who is going to have the decision-making responsibility for major decisions, right? Now, we used to call this custody, and we no longer call it custody anymore, but custody refers to that ability to make major decisions. And major decisions are medical, they are educational, they are religious. So there's religious decisions, educational decisions, medical decisions. Those are the major decisions. So when people say, I'm going to go for sole custody. I lost custody of my kids. What does that mean? It does not mean you don't see your children. It just means that you don't have a say in those major decisions. So what that means is that if a doctor says, hey, kid needs this surgery, and you say, I want the surgery, and your spouse says, I don't want the surgery, if you both have joint custody, then the decision can't get made because you both have a say. You both have your foot in the door, and the party that says, I don't want to have the surgery, gets to sort of block it, and then you have to try to mediate or go to court over who's going to make that decision. Typically, courts won't award joint custody or joint parenting decision-making responsibility to parties that can't agree on these things. But if you have sole decision-making, we don't call it custody anymore. We call it the allocation of parenting responsibility. But if you are the party that has that, then what you say goes. So if you want to have the surgery, you want your kid to have the surgery, then you said it, it happens. The other party says, no, no, no. Look at the divorce document. The judgment says he doesn't have any power. So that party's not going to have the ability to have a say. So we're trying to get to a resolution. And also that independent of that is parenting time. How much time are we going to, spend with the children? Where are they going to live? How many nights a week? How many nights a month? And that is, again, independent of who actually makes the decision. You could have a 50-50 parenting schedule without the ability to make decisions for your child. And so the reason that gets there is, if you go to mediation, you can't work it out. What's going to happen? You go to the judge, and the judge will usually appoint a guardian or a child representative. Those are two sides of the same coin. They are a little bit similar, a little bit different, but it's going to be an attorney that represents the interests of the children. And they are either the eyes and the ears of the court, or they are there to advocate for the children's position. But they will investigate. They will talk to both parties. They'll talk to the kids. They will maybe do home visits, talk to relatives, look at school records, look at medical records, and inform the court saying, hey, after I've done my investigation, I think that dad should be the one to make all these decisions because of whatever reason. And they'll also help say, hey, maybe I think this is what the parenting schedule should look like. They tend to take a very conciliatory approach. They want to get everyone on the same page. They want to try to get everyone to come to an agreement that makes sense. But if they can't, then they'll just tell the court this is what their recommendation is. And a lot of the times, I'm going to say 90% of the time, the court's going to go with whatever they say. And if somebody doesn't like it, there are other steps you can take. You can try to get a custody evaluator, which is a mental health professional, to evaluate everybody involved and see, if there's a disagreement or if there's some other psychological reason as to go against the recommendation of the guardian. And if you don't like that, then you can get your own custody evaluator. And that's pretty much World War III when it comes to a custody fight. And so that's how that whole process works. So hopefully, if that sparked any questions, go ahead, put it in the Zoom chat, or give us a comment on Facebook. And I guess I'm looking at the Facebook Live, and it's basically a lot of people that I know and friends of the firm saying hello from different places around the world. So if anyone else has any questions, go ahead and pop it on the Zoom chat. I'm gonna give another minute or so, and if we don't have any new questions here, I'm gonna go and bid you guys a fond farewell. So anyone here on the Zoom chat, we got a couple people. Any other questions? Pop it in the chat, and let's see what you got. Have you ever had the spouse of your client not respond or show up, and then what happens? Again, great question. So a divorce case is like any other case. It's a court process. And so whether or not you are filing for divorce, or you're suing somebody for a contract, or you are suing somebody because of a car accident, or whatever, the bones of a case all look the same. And so it starts off with, you file your complaint, right? And in the divorce context, especially nowadays, divorce is a no fault situation. Basically, if you want to get divorced, you're going to get divorced. You basically tell the judge in so many words, I don't want to be married, and you're done. So, and no one really, the hows and whys of the divorce don't really come into play. But as it is, I'm going to say it's more than a formality, but you're starting the case off with a petition. You're essentially suing somebody for divorce. You're not suing them for money damages necessarily. You're asking the court to dissolve your marriage, divide your assets. So what happens is, if they're not cooperating, then they have to be served in the same way that any other lawsuit will be served. And this is where the movies take it to the fun level of people walking around in disguises. That doesn't happen exactly, but yes, you have to get either the sheriff or a process server, or somebody else to show up and hand papers to that spouse and say, guess what? You've been served. And at that point, once they've been served, they have a duty to respond, usually within 30 days. And responding means filing their appearance in court. They got to file the proper paperwork at the court, let the court know, hey, judge, I am in the case. I'm here. I'm ready to participate in this case. And once that happens, the court then has the power, which we call jurisdiction, will have jurisdiction over that person to make binding orders. And so once that person's in the case, the judge can order them to do something, and if they don't, then there are consequences. What happens if they don't respond, right? So you've served them with papers and they don't respond. Well, what happens is you basically can get divorced without them. And you tell the judge, well, we served them, they didn't respond. They're going to be found in what we call default. Let's find them in default. And default means that you win by default, right? And whatever opportunity they've had to fight this case, they've lost. And it's really a big deal when you sue somebody for like a car accident, because you basically say, hey, you hit me with your car and I have all these medical bills, and now I'm really hurt, and I want all this money for pain and suffering. And so you want to respond to that in that situation, because maybe the medical bills are inflated. Maybe they aren't really that hurt. Maybe they don't deserve as much money. And if you don't respond in that context, you've lost your opportunity to fight the allegations. Basically, you can't present evidence to respond. Now, in a divorce case, that's kind of a big deal, because you certainly, the party is going to get divorced, but maybe there's some asset that you think is not a marital asset and not subject to division. Well, they say it's marital, and you've lost your ability to say, no, this bank account belongs to me, or this 401k belongs to me, or this house belongs to me, or the money that I put in to the house belongs to me. You now no longer have the ability to do that. And so what happens is you will, if the spouse does not respond, eventually you will go to the judge and you will prove your case, and you will get divorced without that other spouse. Now, that is not without its own complications, because the court can only deal with so many things by default. And, for example, if there's anything that is out of state, any assets that are out of state, the court isn't really going to be able to do that unless the other party shows up. And so there are other property issues. There are certain property issues that the court can deal with, and there's certain property issues the court cannot deal with. And there's issues of spouse support and child-related issues that could come back later. But you can certainly get divorced, and then you will legally be divorced, and that has a legal ramifications. For example, you're no longer accruing a marital estate, so the next paycheck you get, that's going to be all non-marital, and all your own and all personal, and anything you buy with that is similarly going to be non-marital. So that's what happens. Now we have another question. What happens if the spouse responds they don't want a divorce? Well, too bad. If somebody does not want a divorce, it's not really up to them. There was an antiquated way of doing this where, you had to prove a reason. You had to prove infidelity or habitual drunkenness or something like that. And then, if you were able to prove that you weren't actually habitually drunk, or you didn't actually step outside the marriage, then you're not entitled to a divorce. That is sort of old school, very, very old school way of doing things. We don't do it that way anymore. Now we used to have, we have irreconcilable differences, and all it takes to prove that there are irreconcilable differences is for one person to say, yeah, we've got differences and it's not working, and it's not really in my interest to keep going. So, and if the parties are living separate and apart for more than 6 months, there is a irrebuttable presumption, which legally means you can't, overcome it. Means that you just assume that that is the case, and you're going to get the divorce. So if somebody says they don't want to get divorced, there's not really much that person can do. If you want to get divorced, the process allows you to get divorced. So there could be issues about dividing the property, dividing money, paying spousal support, but you can't stop the divorce train from rolling, unfortunately. So very good question. These have all been really good questions, I got to say. Really great questions about really interesting issues. So we got time for a couple more if anyone wants to pop them in there really quick. Let's talk about COVID and divorce. That's a great, great question. So the first most popular question is, oh my God, everything's locked down. Can I get divorced? What's going on? And I'm going to be honest. So I'm here in Illinois, and the court system has actually become amazingly more efficient because of COVID-19. So the process has gone online. I'm doing a lot of stuff. Obviously, emails still work between attorneys, but we have electronic filing, and that is still open. So any motions that need to get filed, any new divorce cases can certainly get filed. And court is running on Zoom, believe it or not. And I just earlier this week on Monday, I completed a divorce over Zoom. I've had a couple of court hearings over Zoom. It's me and the other attorney and the judge. When we got divorced, we got the client divorced. It was me, the attorney, the judge, the court reporter, and the clients. And they were sworn in and they testified, and we did it just like we were in court, except everybody was in their dining room and not suited up. So that is certainly still functioning. I know of attorneys that have had entire trials on Zoom. So that's certainly new. One judge explained to me that she actually liked it because when she does a trial in court, she is sitting up on the bench and the witness is over in the witness stand, and she can only see this profile of the person testifying. But now, because of Zoom, she gets to look head on at the person testifying, can really evaluate whether they are telling the truth, and can evaluate the testimony. So that was really, really fascinating. So, and the process has become more efficient. Now we are emailing things directly to judges or to their coordinators. Dates get put together faster. Documents get processed a little quicker. And I don't have to drive all the way down to the Daily Center. So I think that's pretty nice. And it's actually worked quite nicely. So hopefully some of these changes will stick around. The other big question I get about COVID-19 is, because of COVID-19, can I put a pause on our parenting time schedule? What happens, I'm afraid my kids are going to go out in the world and they're going to catch COVID-19. So I don't want my kids going to, dad's house or mom's house because I can't control it. And at the very beginning, and my hat's off to the Domestic Relations Division in Cook County, they came up with an administrative order that said, no, you have to continue your parenting time schedule. COVID-19 is not a reason to just not have the other party see your kids. But there are other issues that can come up, right? So what happens if you're really on top of social distancing, you're wearing the mask, you're staying 6 feet away, you're not going out, you're avoiding people as much as possible, and but you know that your ex-husband doesn't do that, and he is out at the Wisconsin bars, or he is having people over and having dinner parties and having secret play dates, and all these things we're not supposed to be doing. What happens there? Well, I mean, you can certainly try. This is a situation where maybe you're asking for forgiveness instead of permission. But if you end up in front of a judge, you're going to have to demonstrate why it's a bad idea. And if you can prove that the other party is really not following these guidelines and acting in an unsafe manner, maybe if they're around people, they're going to work, they're around people they know who are COVID positive or were COVID positive. Perhaps you have an elderly person or someone who's immunocompromised in your family. That could be a reason if you show enough facts, a judge may say, hey, this is we're going to have to put a pause on this for the time being. But I will say that now we all started this lockdown in March. It is now June. It's pretty much 3 months, and the sense that I get, I think that people are starting to feel like they're a little more comfortable with this. Although I have seen, Dr. Fauci saying that he's really still concerned about what's going on. He's really concerned about the pandemic is not over. It's certainly still a threat, but Americans do seem to be choosing to live with it and choosing to be okay with it. And everyone's finding their own level of risk that they're comfortable with. And sometimes those levels of risk are not the same between two spouses or former spouses. So that can seriously have an effect. And really, it really does depend on the facts that you're presenting to a judge and what the judge thinks, and whether they believe that everyone's being honest and everyone's acting in good faith. So that's probably the two biggest issues that come up with COVID-19. The other big issue is people who have lost their job. If you have experienced a downturn in your business or downturn in your income because of COVID-19, if you have a spousal support or child support obligation, I would urge you to act quickly. The sooner the better. The thing about spousal and child support is they act as judgments. They do not go away. And every month that goes by that you owe a support obligation, it's like you lost a lawsuit every month, and you're not going to be able to undo it. So couple of text messages between you and your former spouse. Hey, I'm having a rough time. I'll try to make it up to you. No worries. That's not going to cut it, because that spouse can always turn around and say, hey, it's $800 a month. It's been 4 months. You owe me the money. Let's pay up. And judges don't really care where you get the money. They want you to get the money, and they want you to pay it. So if you have a downturn in your job, that is something to act on really quickly, because you want to make sure you've got your stake in the ground. You cannot go back with child support beyond the date you file your petition to change it. So the date you file it with the court is probably the most important date, because at least now you got your foot in the or a stake in the ground to that date to say, hey, at least we can go back and get it modified back to the date of filing. The longer you wait to bring it to the court's attention, the harder it is to undo it, if at all. So that's probably the biggest three things that COVID has done to my profession. Everyone's saying I'm going to get a whole ton of divorces. I've seen a regular flow, but I don't think I've seen the gigantic wave that everyone's talking about. I've heard the same thing from other lawyers. But maybe once people are out and about, they're going to either this has been really good for marriages or really bad. So time will tell. All right. If I don't see any more questions here, let me see if I got anything on the Facebook. I don't. And let's see if I've got any more in the chat. I don't think I do. It's now 2:00. I think we had a good time. Anything else? Anyone else want to throw anything into the chat real fast? Jill, do we have anything?
I do not see anything.
Well, listen, I want to say thank you to everyone that came in on the Zoom chat, everyone that's on Facebook Live, everyone that's commenting, asking these questions. I really appreciate it. I'm going to make this a regular thing, I think. And so watch the space, subscribe to our YouTube channel, or like our Facebook page, Hecht Schondorf. We're here in Northbrook, Illinois. I am Mark Schondorf. I'm the divorce lawyer that means business. Very happy to talk to all of you, and thank you very much. So have a good one. Have a good day, and be well.